Joining us now, MSNBC Justice and Intelligence correspondent Ken Delaney and MSNBC legal correspondent Lisa Rubin, former Deputy Assistant Attorney General Tom Dupree, and Lawfare's legal fellow and courts correspondent Anna Bower. Anna had an interesting few days. We're going to get to that in just a moment. Ken, let me start with you. This legal filing, a lot of words, a lot of different ways to say one thing. This case is political retribution, and that is illegal under the law.
Yeah, that's right, Katie. And in fact, what they're saying is Exhibit A, of course, is Donald Trump's Truth Social post, which may or may not have been intended as a direct message to his attorney general, where he called Comey a bad guy and said that he should be prosecuted. And it's just really hard to argue with that. I mean, it's out there for the world to see. But Comey does, and his lawyers do, include a raft of other evidence in this motion, including the fact that the Justice Department fired his daughter, who is a prosecutor in the Southern District of New York, without cause. But what's really interesting to me is that after amassing this set of evidence in this lengthy motion, essentially Comey's lawyers make this pitch to the judge. Look, if you don't want to rule in our favor based on this information, let us have discovery and we'll have an evidentiary hearing. And what that means is they will want to get all the communications between the White House and the Justice Department about the Comey case and all the machinations about the career prosecutors who didn't want to move this case forward, and who in the White House was pushing who in the Justice Department to bring the case forward. And all that would buttress a case that this was a vindictive and selective prosecution. If they get that, this is going to take a long time, first of all, for the DOJ and the White House to produce. There'll be battles over which documents get produced. But we will learn a lot more than we know now about exactly how this case came to be, and that will be fascinating.
That right there is really interesting, Tom.
Well, it sure is. And look, to state the obvious, maybe, it would be exceedingly unusual for a district judge to allow that kind of discovery into the behind-the-scenes machinations and the discussions among prosecutors and the president. That said, this is an extraordinary case. My sense is that this motion, I don't think, is likely to succeed in getting this indictment thrown out, at least at this time. I'm not faulting the defense for bringing it. If I were in their shoes, I would litigate this case aggressively. I would take that shot. But the standards for getting a case dismissed on grounds of vindictive or selective prosecution are so high.
Well,
so many motions are filed and none
succeed. If this doesn't meet it, what does?
Well, maybe nothing does. But the fact is that judges are extremely reluctant, to say the least, to throw a case out on these grounds. I think they have much better chance of taking the shot at the appointment process through which Lindsay Halligan got this job. That also presumably would lead to dismissal of the indictment and is a far less legally difficult, complex road for the judge to travel if he wants to throw this case out.
I can feel you wanting to chime in.
I was going to say, I agree with Tom that is the better of the two legal arguments, but I just want to underscore from their brief how unusual this particular case is, because I can't think of any other circumstance in which a criminal defendant comes forward and says, these are the things the president of the United States has said about me. So I'm going to read from the brief. Among other things, President Trump has publicly called, and these are all quotes, Mr. Comey a corrupt piece of garbage, a disgraced liar and leaker, a weasel, a weak and untruthful slimeball, and very sick or very dumb. Those statements reveal a deep personal animus toward a perceived political enemy. And the standard for vindictive prosecution, which is a separate legal concept than selective prosecution, is about a particular person's animus toward the defendant. It's hard for me to conceive of a case with more animus than this one.
Yeah, you know, you keep correcting me because I keep mislabeling it as a selective prosecution. And you lawyer me and you say, you know, you got to get your terms right. It's vindictive. I guess I'm just
they're doing both.
I'm stuck on this, though. Why even have it if there's never going to be a case that amounts to it? If you have the president of the United States in a direct message that was public or a public message, whatever, saying, I want these people prosecuted, how does that not meet the standard? And if it doesn't, what's the point of having it?
Well, I mean, I think the point of having it is to ensure to the greatest extent possible that justice is not corrupted by personal vendettas and vindictive motives and the like.
Yeah.
But look, the thing here is that the government is going to be able to credibly say, look, yes, absolutely, Trump hates Jim Comey. I mean, you know, you could have gone on for 10 minutes with those sorts of things that he said about him. No question about it. But I think they would say, look, there is some evidence here from the government's perspective that would support a conviction. And so let the process play out rather than throw this out. If there was no evidence supporting it whatsoever, then maybe you would have a vindictive prosecution argument. But I think what they would say here is, look, yeah, it is vindictive, it's retributive, but there is some evidence supporting it, so that's why it should go to a jury. That's the defense.
Anna, let's talk about Lindsay Halligan. So we have her in this prosecution of James Comey. She's also prosecuting Letitia James. And you had, I guess I'll call it, an interesting experience with her regarding the Tish James reporting, which, by the way, wasn't even yours.
Yeah, it was a very highly unusual interaction that we just published all of these text messages yesterday. Lindsay Halligan, who, again, contextualizing this, sitting United States attorney handling two of the most high-profile prosecutions in the country against the president's perceived political enemies, reached out to me in a text message, unsolicited, to object to a tweet that I wrote in which I summarized someone else's reporting, particularly a New York Times story in which I summarized reported grand jury testimony. Now, look, this is highly unusual for a number of reasons. One of them being that, typically federal prosecutors just don't talk publicly about ongoing prosecutions, and they typically don't really get anywhere near the subject of grand jury testimony because there are Justice Department policies and federal rules that prohibit the disclosure of any matters that occur before a grand jury. So all of this was very surprising to me. And, look, I had never seen an interaction between a U.S. attorney and a journalist like this. Neither had my editor, who has been reporting on legal affairs for decades. In the course of reporting our story, we spoke to multiple former federal prosecutors, legal journalists, and none of them had ever seen an interaction like this either. So I think that it really underscores the lack of experience here. Lindsay Halligan had never been a prosecutor before she got into this position. And it also, again, I will also remind people as well that all of it was on the record. And so also seems to underscore some kind of lack of understanding of how to engage with the media as a person who's a high profile public figure. Although, she certainly has experience engaging with the media, given her past as a member of Trump's defense team.
Let me talk about the specifics of what she was arguing with you. So Letitia James is being accused of mortgage fraud, being accused of having a property that she said would be her primary property, also a property that she wouldn't rent out. And in the New York Times reporting, you found a contradiction there, like that she was not actually reporting what the DOJ was accusing her of reporting. The facts of that house didn't line up with what the DOJ had been arguing in grand jury, in that grand jury room. And she took issue with what?
Yeah, so look, the indictment alleges that Letitia James claimed that she was using a property as a second home, when in fact she was using it as a, quote, rental investment property. So the idea there is that there's some kind of false statement or a fraudulent intent in saying you're using the house for one thing when really you're doing another. The New York Times report said that Letitia James's grand niece is the one who occupies the property, and that during this grand jury testimony, she reportedly testified that she'd lived there for many years and that she did not pay rent. So I summarized that reporting in a tweet, made it very clear I was crediting the New York Times, and what she reached out to me about seems to be that summary or my additional commentary in a different tweet in which I said, hey, this seems to suggest to me that this could be exculpatory because it undermines the idea that the primary purpose that James was using this home for was to collect rent money. And so what she did in these text messages is say, you should read the indictment. It alleges that she collected thousands in rent money. I objected to the idea that that's necessarily a contradiction, because if you look at the indictment, it's not specific as to the amount of rental money that was collected. It could be a very small amount. It could have been many years ago. So that doesn't necessarily contradict the reported testimony. We had this back and forth about this. Ultimately, she could not tell me exactly what was inaccurate about what I'd posted. And so that was part of what was so frustrating about it, is that, she approached me and saying something was inaccurate, but then ultimately would not tell me what.